go, please. Let's go. Come on.
No, what you're not going to do is touch me. I haven't done anything.
Let's go. Come on, ma'am.
Have I done anything, sir? No, don't touch me. No, please don't touch me. You cannot touch me.
You do that, it's going to be a problem.
Imagine this. You miss your flight. You sprint to the counter. You want answers. You haven't touched anyone. You haven't threatened anyone. All you've done is talk. Now imagine a deputy walks over.
There's two gates on it. You can ask somebody. Ma'am, what? Ma'am, what? I haven't done anything. I'm speaking to Spirit Airlines about my flight.
Okay.
About my flight.
It's gonna go two ways.
No, it's not gonna go any way because I haven't done anything violent. I haven't done anything. All I did was speak. All I did was speak.
I'm trying to be friendly.
Broward County Sheriff's Office. What did you come over here to do when I'm talking to Spirit Airlines? I'm not disrupting anybody. I'm talking to her. I'm not disrupting anybody. I'm talking to her. I'm disrupting anybody. I'm talking to her. I understand that. I'm trying to get some information. No, I'm getting clarification. Yes, okay, come over here when I'm getting clarification about my business matters. I haven't done anything wrong. I haven't insulted her. I haven't cussed her. I haven't touched her. I haven't done anything. I can stay right here and talk about my flight. You coming over here and trying to intimidate me ain't gonna do anything because I haven't done anything illegal.
Do I look intimidating? You're the one that's looking
I
intimidating.
didn't do anything illegal, so you coming over here to come in my business has nothing to do anything.
Right,
Be a soul. Be a soul.
So she's done?
Be a soul.
Okay, so you gotta leave.
Okay.
No, I'm talking about my flight.
Listen.
I'm talking about my flight. I'm talking about my flight.
All right.
No, don't touch my stuff.
Listen. We're gonna give you 10 seconds.
Let's go, please. Let's go. Come on.
No, what you're not gonna do is touch me. I haven't done anything.
Let's go. Come on, ma'am.
Have I done anything, sir? No, don't touch me. No, please don't touch me. You cannot touch me.
You do that, it's going to be a problem.
I'm not even touching you. I'm not doing anything.
You're gonna walk or not?
I'm not doing anything. I'm not doing anything.
Okay.
Am I being arrested? Am I being arrested? Am I being arrested? Am I being arrested? Am I being arrested?
Tells you to leave, you ask why, and the next thing you know, you're in handcuffs, being charged with trespassing on critical infrastructure. That is exactly what happened on June 24, 2025, at Fort Lauderdale Hollywood International Airport, and the entire thing was caught on camera. Today we are going to go through this footage frame by frame. We're going to talk about what the law actually says. We're going to talk about what these deputies got right, and what they may have gotten seriously wrong. And I want to be upfront with you before we start. I am not a practicing attorney. Nothing I say here is legal advice. What I offer is informed legal analysis based on published case law, constitutional doctrine, and the footage itself. As always, I'll let the evidence speak. So, was she wrong? Were the deputies wrong? Or is the truth, like it almost always is, far more complicated than the headline? Let's get into it. Before we get into the video, I want to give a very special shout out to everyone who's been watching, sharing, and commenting. You are the reason this channel exists. If you're new here, welcome. We analyze police encounters through the lens of constitutional law, actual case precedent, and the footage itself. Not outrage. Not agenda. Evidence. If you want to support the work, hit subscribe, drop a comment with your name and where you're watching from. I love giving shoutouts. And if this kind of breakdown is your thing, the like button tells the algorithm to push this to people who need to see it.
Stop squeezing it! Stop squeezing my arm! You are squeezing it! Stop squeezing it! Videotape, you're squeezing it! You are! Stop!
Stop.
I'll watch for you.
Just sleep with her.
Ebony here?
Get your hands. Please. He's hurting me. He's hurting me. You see how you're holding me loosely? He's tagging me on purpose. And then he's pulling my arm. Look how it's all skewed. It's hurting me.
Just explain to me so I know what.
She did tell you more.
Who?
Because she was the gay agent. I had to run from the front
so
when they
what
came
happened?
over here.
Just tell me what happened so I know.
Paola closed the door at 14.
Okay.
Okay? She walked in, and then as soon as she walked in, see this lady sprinting.
Okay.
And then she came to the counter. I'm like, ma'am, you're going to have to go to across from G10 to be rebooked. Before I even get to finish my sentence, she started getting all rowdy. Calling me names, telling me you're going to get me on the flight, da-da-da-da. And then I called her, and then she can hear her screaming. when she was coming down. She just kept getting hot, like
Can I get a picture of your little thing? So basically, she came here already had an attitude. Right?
Yeah.
She was late.
She said she was at the wrong gate. Whatever day she was at.
Okay.
We don't have E13.
No, that's in Terminal 3.
No, we don't have E13.
We
Oh, no,
don't
not
have-
E13, but yeah, that's in Terminal 3.
Yeah, but I'm trying to explain to her, ma'am. Well, that's what the person said when I walked out of TSA.
No one said that.
No one said
So,
that.
okay, so, and then when I came to talk to her, she wanted to get all loud. So I already knew what was going to happen.
Yeah.
So, okay.
That's it.
All right.
But I needed her name because I wanted her to document. So before you come, that's what she was trying to give me. Because I said, can I see your boarding pass?
How long are you going to be here for?
So 1 a.m. I got to this side.
Oh, so you're going to,
I'm gonna be
you'll be
here,
here in
sir.
20 minutes?
Yeah.
All right, I'll get her name for you if you want to.
All right, thanks.
All right. No problem. I'm warning you right now. Listen, I'm not gonna talk to you. You kick my door again, I'm gonna press charges for messing up my vehicle. Yes, you do it again. You do it again. Okay, you do it again.
What's wrong with your vehicle?
You do it
Are
again.
you pressing charges against me? Yes or no?
Ma'am, you're going to jail. Yes, you're going to jail for trespassing. You're going to jail. That's it. Simple. I'm done. I'm done.
Trespassing.
Kick my door again. I'm a add charges. I'm a add charges.
Where did I trespass at?
I'm telling you right
I'm
now.
pressing charges. And where did I trespass at? Where am I trespassing, sir?
I'm done talking.
Are you still 10-6
Where
or
was I
did you want me to come
trespassing
in?
that you're arresting me?
You know where.
Where was
You
I
know where.
trespassing? I don't know where I was
Okay.
trespassing.
All right, then.
I'm trying to get clarification.
All right, no problem.
You didn't even give me my Miranda rights when you arrested me.
Okay.
You didn't even give me my Miranda rights when you arrested me. You arrested me with no Miranda rights. You arrested me with no Miranda rights. You didn't say you had a right to be silent. You arrested me with no Miranda rights. You arrested me with no justification on what you're arresting me for. You're taking me to jail with no clarification on why I'm being arrested. You're saying I'm trespassing someplace that I have a ticket to be. Always a black man. Always a black man. Always. I hate y'all.
Ma'am.
Shut the f*** up. Shut the f*** up. Dumb.
Okay, now I'm not talking.
Shut up. I hate y'all. If it's not you guys beating on us, it's you guys doing some shit. You guys are always attacking us. Like, I hate black men. I hate y'all. I hate you guys so much. Like, if it's not one thing that a black man will do to a black woman, it's another thing. If it was a white girl, I swear to God you wouldn't have gone to this lane. But because I'm black, you want to make sure you don't throw the block at me. I hate y'all. Black men are the worst. Black men never protect
Yeah,
us.
19, yeah.
Black men are worst. I pray if you have daughters, black men them up too, like you are trying to me up now. You got kids, I pray they go through this shit.
And does
Every
Mr.
last
Working use
one.
any of this?
I hope they get all this shit over something minimal, if not worse. I pray that shit rains on your family's head.
14 on the 10-year case number is 1741.
They shall never rest because of this shit here. I rain it on your head, your kid's head, your kid's head, your kid's head. I rain on the generations from you that they will never rest over this night. They will never rest. They will never rest. They will never see anything good in their life.
Right. Let's set the scene. June 24th, 2025. Fort Lauderdale Hollywood International Airport. One of the busiest airports in the southeastern United States, and a facility that, under Florida law, carries a specific legal classification we're going to come back to. Broward County Sheriff's Office deputies are dispatched to a Spirit Airlines counter after receiving reports of a woman causing a disturbance. She had missed her flight. Now, let's be honest with each other for a second. We've all been in an airport when things go sideways. Missed flights are stressful. They can cost hundreds of dollars. They can mean missing a wedding, a funeral, a job interview. Emotions run high. That's human. That's understandable. But here's where it gets legally interesting. Because the moment a deputy arrives on scene, we are no longer just talking about a customer service dispute. We are now inside the framework of the Fourth Amendment of the United States Constitution, the one that protects against unreasonable searches and seizures. And we are inside the framework of Florida trespass law. And we are inside the framework of a person's First Amendment right to speak and petition. Several parties are involved in what we're about to watch. There is the woman, let's call her the passenger. There are the Broward County deputies. And there is the Spirit Airlines gate agent, Paula, whose account we also hear on tape. What we have here is a collision between someone who believes, passionately, that she has done nothing wrong, and law enforcement that has made a decision to remove her from the premises. The question the law asks is not, was she being difficult? The question the law asks is, was there a constitutional and statutory basis for what the deputies did? Let's find out. Right out of the gate, no pun intended, we see the deputy approach the passenger while she is mid-conversation with the airline agent. The deputy says, and I'm quoting directly from the footage, "It's going to go two ways." Now, let's slow down there. Because those 5 words are legally significant. What the deputy is signaling is a binary, comply or face consequences. And the passenger's immediate response? She says she hasn't done anything violent, she hasn't done anything at all, she's just speaking to the airline about her flight. Here is the first legal question this raises. At this moment, does the deputy have sufficient basis to intervene? Under Florida Statute 877.03, disorderly conduct requires behavior that corrupts the public morals, outrages the sense of public decency, or affects the peace and quiet of persons who may witness it. Simply arguing with a customer service agent, loudly, frustratedly, has been found by Florida courts to be insufficient for a disorderly conduct charge unless accompanied by physical behavior or direct threats. The gate agent, Paula, later tells the deputy what happened. The passenger arrived after the gate was closed. Paula directed her to a different counter for rebooking. Before Paula could finish her sentence, she says the passenger, quote, started getting all. The audio trails off, but she describes the passenger calling names and demanding to be put on a flight. Now, name-calling is not illegal. Being loud is not illegal. Being rude to a customer service agent is not a crime. This matters. But here's what also matters: the deputy was called. And once law enforcement arrives on scene in response to a disturbance call, their authority to manage that scene is broader than you might think. Under Terry v. Ohio and its progeny, officers responding to a reported disturbance have the authority to investigate and take steps to de-escalate. The question is not whether they can be there. The question is whether what they do next passes constitutional scrutiny. And what they do next is try to remove her. Watch what happens when the deputy tells her she has to leave. She says, and this is key, "No, I'm talking about my flight." She is not throwing things. She is not threatening anyone. She is asserting that she has a right to be at that counter and a right to resolve her ticketing issue. The deputy gives her 10 seconds. She doesn't move. Physical contact is initiated. And this is where we need to talk about what the law actually says about police touching a person who has not been placed under arrest. The Fourth Amendment's protection against unreasonable seizures applies the moment a reasonable person would not feel free to leave. The Supreme Court made this explicit in Florida v. Bostick in 1991. Once that threshold is crossed, once it becomes a seizure, there must be either reasonable articulable suspicion of criminal activity or probable cause for an arrest. At the moment deputies initiated physical contact to move her, the question becomes, what was the legal basis? The most likely answer the deputies would give is, trespass. And we will get to the trespass charge in a moment, because that is where this case gets truly complicated. But notice something. As she is physically being moved, she begins asking, repeatedly, and I mean repeatedly, "Am I being arrested? Am I being arrested?" She asks this question something like a dozen times. That question is not just panic talking. That question has legal significance. In Berkmere v. McCarty, a 1984 Supreme Court decision, the court affirmed that a person who is detained must be told the nature of their detention. And in Hybel v. 6th Judicial District Court, the court clarified the line between a Terry stop and a full arrest. She is asking, what is my legal status right now? And the deputies, for several exchanges, don't answer her directly. They say things like "let's go" and "come on." It is only later that the word trespassing is used. Now, does failing to immediately announce an arrest make it unconstitutional? Not necessarily, in and of itself. But it does raise questions about whether the encounter was procedurally sound from the outset. And then there's the use of force. She alleges on camera, multiple times, that the deputy is squeezing her arm, tugging it, hurting her. The deputies deny this. One deputy at one point holds his grip openly to show it is loose. Under Graham v. Connor, the landmark 1989 Supreme Court case that governs all police use of force, force must be objectively reasonable in light of the facts and circumstances confronting the officer. Courts look at the severity of the crime, whether the suspect poses an immediate threat, and whether they are actively resisting or attempting to evade. She is not accused of a violent crime. There is no evidence she posed a physical threat. And her resistance appeared to be a refusal to walk, not active physical aggression. That doesn't mean the force used was necessarily excessive. But it is a question a court would ask. She was charged with trespassing on critical infrastructure. Let's unpack that, because there are two different legal questions buried in that charge, and most people are only thinking about one of them. The first question is, can you trespass somewhere you have a ticket to be? The second question is, what is critical infrastructure under Florida law, and what does that charge mean for her? Let's take them in order. Florida Statute 810.09 defines trespass as willfully entering or remaining in any structure or conveyance without being authorized, licensed, or invited. The key word is remaining. Because trespass isn't just about where you entered, it's about whether you were lawfully authorized to be there at the moment you were told to leave. Here's the tricky part. Spirit Airlines, as the operator of that counter and gate area, has the right to revoke authorization. This is well established in property law and airport law. When a customer service dispute escalates to the point where the airline requests law enforcement intervention, the authorization to be in that specific restricted area can be, and legally was, in this case, revoked. In other words, having a Spirit Airlines ticket does not give you an unlimited right to remain at the counter indefinitely, and refuse to leave when asked by law enforcement. Once the deputies lawfully ordered her to leave the Spirit counter area, and she refused, the elements of trespass may have been satisfied under the statute. Now, she argues this passionately. She says, I have a Spirit Airlines ticket and you're arresting me for trespassing. And I understand why she feels that way. It feels deeply contradictory. And in the court of public opinion, that argument resonates. But the law draws a line between the right to enter a place and the right to remain after you've been told to leave by someone with authority to tell you. Airport counter areas are not fully public forums. They are semi-private commercial spaces inside a public facility, and the rules are different. Now, the critical infrastructure designation. This is where the charge gets significantly more serious. Under Florida Statute 810.0975, trespass on critical infrastructure is a third-degree felony. Florida specifically designates airports as critical infrastructure. So we're no longer talking about a misdemeanor trespass. We're talking about a felony charge. This is an aggressive charging decision. And prosecutors will have to weigh whether the facts, a woman arguing at an airline counter, rise to the level of felony trespass on critical infrastructure, which is typically applied to individuals who breach secure perimeters, tarmac areas, control towers, and the like. The counter area where this incident occurred is a publicly accessible part of the terminal. Whether that area qualifies as critical infrastructure under the statute for purposes of the felony enhancement is a question her defense attorney will absolutely challenge. And I think they'd have arguments worth hearing. She raises this on camera while in the back of the patrol vehicle, and it's a point worth addressing directly. She says, "You didn't even give me my Miranda rights when you arrested me." Let's be precise about what Miranda actually requires, because this is one of the most widely misunderstood legal concepts in American life. Miranda v. Arizona, the 1966 landmark decision, requires that before a custodial interrogation, officers must advise a suspect of their rights: the right to remain silent, that anything said can be used against them, the right to an attorney, and the right to a court-appointed attorney if they cannot afford one. The critical phrase is custodial interrogation. Miranda does not require officers to read your rights the moment they arrest you. It requires them to do so before they question you in custody. So, if officers arrest someone and then immediately place them in a vehicle and do not ask them any questions, Miranda warnings are not yet legally required at that moment. The failure to Mirandize before questioning, however, can result in any statements made being suppressed at trial. Now, there is one nuance worth noting. In Berkmere v. McCarty, the Supreme Court held that roadside questioning during a traffic stop doesn't typically constitute custody. But a full arrest absolutely does. So if deputies at any point questioned her in a way designed to elicit incriminating statements after placing her in handcuffs, without Miranda warnings, those statements have suppression issues. What I'd say to her directly if I could, the Miranda argument matters less than you might think for your immediate situation, but it matters a great deal if statements you made in that patrol car are later used against you at trial. I would be doing this analysis a disservice if I didn't address what she says in the patrol car. Because what she says, in the heat of the worst moment of her evening, is something that tells us something important about her state of mind, and something important about the broader context we're operating in. She says, and I'll be honest with you, she says some things that are difficult to hear. She directs intense anger at black men, at the deputies. She invokes race, always a black man, in the context of the encounter. She curses. She says things she would probably not say in a calmer moment. I'm not going to perform outrage about this. I'm going to do what I always try to do on this channel, put it in context. This is a woman who has just been physically restrained, handcuffed, and placed in the back of a police vehicle because she argued at an airline counter. Whatever you think about the legal merits, from her perspective in that moment, she has just had her body seized by law enforcement in a public space for, as she puts it, talking. The emotional response, however misdirected, however ugly some of the language, is not difficult to understand when you look at the history of black women in interactions with American law enforcement. None of that language helps her legal case. None of it. Statements made in custody can and will be noted. And the curses and the expressions of racial anger, while legally protected speech in the abstract, can color a jury's perception of her character. But let me say something that I think needs to be said plainly. The anger she expresses is not evidence that the arrest was lawful. Emotional response after the fact does not retroactively justify the police conduct that preceded it. We do not evaluate the legality of the initial seizure based on how a person reacts to being seized. These are two separate questions, and a court will treat them as two separate questions. Let's talk about Paula. Because the gate agent's account to the deputy is important, it's one of the key factual foundations for the trespass charge. Paula tells the deputy that the passenger came to the counter after the gate was already closed. She tried to direct her to a rebooking counter, G10, before the passenger began calling her names and demanding she be put on a flight. Paula says the passenger came in already with an attitude and just kept getting hot. There's a factual dispute embedded in this. The passenger claims she was directed to the wrong gate by someone when she exited TSA. The Spirit agents say no one said that. This he said she said element is going to matter if this goes to trial. But here's what I want you to notice legally. Paula's account, even taken at face value, describes calling names, demanding to be put on a flight, and getting hot. It does not describe physical threats. It does not describe threats to destroy property. It describes an angry, frustrated customer. That context will be relevant to whether the officer's response was proportionate. And Florida courts have repeatedly held that verbal altercations alone, without more, do not justify escalating uses of force. The underlying conduct that triggered the call matters when evaluating the response. Let me bring the whole legal picture together now. Because I want to make sure you leave this video with a clear framework, not just a feeling. Question 1. Did the deputies have the right to intervene? Likely yes. They were called to respond to a reported disturbance. Under well-established case law, officers responding to a disturbance call have the authority to investigate and manage the scene. This part is not legally controversial. Question 2. Did the deputies have the right to order her to leave the counter area? Probably yes, particularly once the Spirit Airlines agent indicated they wanted her removed from that area. As the occupant of the commercial space, Spirit had the authority to revoke her license to remain at the counter. Deputies acting on that authority are on solid legal ground in ordering her departure. Question 3. Did her refusal to leave constitute trespass? Under Florida Statute 810.09, probably yes, once she was lawfully ordered to leave and refused. This is where her I have a ticket argument struggles. The ticket gives her the right to fly. It does not give her an unlimited right to remain at a specific counter area after law enforcement orders her to leave. Question 4. Does the critical infrastructure felony enhancement apply? This is the most legally vulnerable part of the charge. Fort Lauderdale Hollywood International Airport is designated as critical infrastructure under Florida law, but the enhancement is typically applied to breaches of secured, restricted areas. Whether a public-facing ticket counter qualifies is an open legal question that defense counsel will vigorously contest. Question 5. Was the use of force appropriate? Under Graham v. Connor, the force must be objectively reasonable. The severity of the offense, the level of threat, and the resistance level all factor in. Her offense was a non-violent refusal to leave. The force appears, based on what is visible in the footage, to have been minimal restraint rather than anything approaching excessive force. But the allegations of arm squeezing, if documented by injury, are something any competent attorney would investigate. Question 6. Were her Miranda rights violated? Not necessarily at arrest. Miranda warnings are required before custodial interrogation, not before arrest itself. If she was questioned while in custody without warnings, those statements face suppression. This case is a microcosm of something much larger that plays out in American public spaces every single day. Airports are liminal spaces. You're not quite in the street, you're not quite in private. You have rights that diminish the deeper you go into security. You have commercial entities managing spaces inside publicly funded infrastructure. And you have law enforcement with broad authority to maintain order in what Florida designates as a critical piece of public safety infrastructure. The passenger in this video is not a villain. She is a person who missed a flight, lost her composure, and found herself caught in a web of overlapping laws that most Americans have never read and would never think to look up. And the deputies are not, based on the footage, running amok. They are managing a situation they were called to manage, using tools and authority the law gives them. The real issue, and I say this as someone who studies these encounters carefully, is that the gap between what the law technically allows and what feels just to an ordinary person is vast. And that gap is where most of the anger in these videos lives. She wasn't wrong that she had a ticket. She was wrong, legally, that the ticket was enough. That's not a personal judgment. That's what the statutes say. So what do we take away from all of this? 1. Having a ticket to an airport does not give you an unlimited license to remain anywhere in that airport under any circumstances. Once law enforcement, responding to a reported disturbance, orders you to leave an area, your legal options narrow quickly. And in Florida, with the critical infrastructure statute on the books, the stakes are higher than most people realize. 2. The felony critical infrastructure charge is aggressive and legally contestable. Whether a public ticket encounter qualifies as critical infrastructure for purposes of the felony enhancement is a real question that will be litigated. 3. Miranda rights matter, but not in the way most people think. They matter for suppression of statements, not as a procedural defect in the arrest itself. 4. Use of force analysis under Graham v. Connor is fact-specific and footage-specific. What we can say is that the force visible in this clip does not, on its face, reach the threshold of obvious excessive force, though a formal complaint and investigation would be appropriate if she sustained documented injuries. And 5. The emotional response in that patrol car, as understandable as it is in human terms, does not help her legal situation. If you ever find yourself in a similar circumstance, remain silent. Ask for a lawyer. Every word you say in that car can and will follow you into the courtroom. If this breakdown gave you something to think about, please like the video and subscribe to the channel. Drop a comment below with your take. Do you think the critical infrastructure charge is justified? Do you think she was treated fairly? I read every single comment. And if you want to get a shout out in my next video, tell me your name and where you're watching from. Until next time, stay informed. Know your rights. And remember, the law doesn't care what feels right. It cares what the statute says. See you in the next one.